How is everyone?
Good, Mr.
I'm
Chair.
fine, Mr. Chairman.
Good, Mr. Chair, thank you.
Mr. Adams.
Good afternoon. I'd like to take this opportunity to welcome everyone to the House Economic Matters Committee. Today is Tuesday, February 9th. We have 4 bills before us. We will start with House Bill 726 with Delegate Ivy, followed by House Bill 683, 684, 685 by Delegate Valderrama. She must have dropped all these bills at the same time. And with that, we will get started. Delegate Ivy, welcome to the House Economic Matters Committee.
Thank you, Mr. Chair. Forgive me. Colleagues, for the record, Delegate Julian Ivy here presenting House Bill 726. Under state law, the Maryland Apprenticeship and Training Council must, to the extent practicable, reflect the geographic, racial, ethnic, cultural, and gender diversity of the state. As introduced, House Bill 726 further specifies that the Maryland Apprenticeship and Training Council must include representation of individuals who are Black and Latino. The purpose of this legislation is to ensure that the needs of Maryland's Black and Latino populations are being included and represented in Maryland's apprenticeship and training programs.
Yes.
Our apprenticeship programs are an essential component to building up Maryland's workforce in many low-income communities of color, providing individuals with an opportunity to learn new skills and earn higher wages. Black and Latino representation on the council will allow for innovative and diverse apprenticeship programs designed to promote economic growth in our low-income communities of color. These populations have been most severely affected by the COVID-19 public health and economic crisis. Thus, as we rebuild our state's post-COVID economy, we must ensure that Black and Latino populations are represented on the Maryland Apprenticeship and Training Council. Just earlier today, this piece of legislation received unanimous support from the Prince George's County Council with a slight amendment to clarify that when we're referring to Black, we're referring to African Americans, which is something to be considered as well by this committee. This bill was also cross-filed in the Senate by Senator Patterson. I'm asking for a favorable report on House Bill 726. Thank you.
Thank you, Delegate Ivy. Any questions of the delegate? Seeing none. That concludes the witness list for House Bill 726. So that is we will declare House Bill 726 bill hearing as having been done. Thank you very much.
Thank you, Mr. Chair.
Delegate Valderrama, are you ready with House Bill 683?
Yes, Mr. Chairman, thank you.
Thank you.
Good afternoon, colleagues, esteemed members of the Economic Matters Committee. For the record, Valderrama here to present House Bill 683, Medical Cannabis Compensation and Benefits. Let me just preface before I get into my testimony that I'd like to ask each and every one of the members here to really pretty much keep an open mind, because I know when they hear the term cannabis, everyone gets a little crazy, and especially when it comes to workers' comp, of which the subcommittee I chair. But I have to tell you that just a very background, that the whole premise for this legislation has come to my attention and my crossfile across the street, Senator Feldman, where we had the privilege of speaking to one of the lead panelists who will be with us following my testimony, where he has gone through some extreme measures just to feel a bit of relief for his injuries that he has succumbed to. I shouldn't use the word succumb, he's with us, but you get the gist of what I'm saying. And I say all of this to say is that please don't think of the term cannabis as bad, evil, or otherwise, and to also remind our members that we successfully passed medicinal marijuana. So, it is also my understanding that many of the members here, my colleagues, have been reached out by our lead panelist, Mr. Aaron Shepard, and many of you have given very positive responses and listened to his plea. And so on behalf of Mr. Shepard and the many Marylanders who are suffering and need medicinal marijuana for workers' comp benefits, I'd like to speak on their behalf. And so with that said, again, here to present House Bill 683, which would allow workers compensation payment for medical cannabis that is taken pursuant to the written certification of a certifying provider obtained in accordance with our medical cannabis statute, which is Title 13, Subtitle 33 of the Health General article. As our great state has gained experience with medical cannabis, we have found that it can be a very safe and effective treatment for short-term or chronic pain. And it's for this reason that I and many others believe that now's the time to recognize medical cannabis as a therapy for workers' compensation patients who are looking for an alternative to opioids for pain relief. It is widely accepted that in the United States that there is a severe opioid drug crisis, and I think we can all attest to that. This class of drugs include like OxyContin, Percocet, and Vicodin. But even short-term use of opioids, though oftentimes necessary, is quite risky. And the CDC has found that addiction to these drugs can occur in as few as 5 days. And although addiction does not happen in the majority of these cases, when opioids are taken under medical supervision, the story of those who have become addicted is all too familiar. And so, the story goes a little something like this. A patient is injured or has surgery and is prescribed an opioid to manage his or her pain. This is accepted medical procedure, but because opioids are highly addictive and pain is highly subjective, a patient may need a higher and higher dose to achieve the same pain relief. So in most cases, at some point, a physician will refuse to write further prescriptions for opioids, and the patient is left to their own devices. So they can quote unquote kick by going cold turkey or seeking a drug addiction program, or they can be forced to illegally buy their supply on the street. In part as a response to this crisis, many of us here on this committee, some not, Maryland legalized medical cannabis. So the Natalie M. LaPrade Commission oversees the implementation of Maryland's safe and effective medical cannabis program. So while 33 states and the District of Columbia have legalized medical cannabis, only 5, which are Connecticut, Maine, Minnesota, New Jersey, and New Mexico, require workers' compensation coverage. What I forgot to preface before my testimony is that for some reason I looked on the floor system and there have been amendments made to this bill that are not reflective and I can't get them. So if anyone else can see them, that's great. But I'm happy to provide that once I get a copy of it. I just received notice that it should be on there and it is not. So with that, again, just want to ask everyone to keep a very open mind, especially my members on the subcommittee, because I feel we will be having a subcommittee meeting on this and other measures that are coming before our subcommittee, and ask each of you that now's the time for Maryland to join these 5 other states. And I ask for a favorable report of House Bill 683.
Thank you very much, Delegate Valderrama. Are there any questions of the sponsor?
Yes, Mr. Chair.
Let me start with Delegate Szeliga. Thank you very much for joining us. I'm sorry, didn't realize we had members of our sister committee with us. Who is, I think I see Delegate Lewis as well. Well,
Delegate Johnson too.
And Delegate Steve Johnson. Got it. Sorry, I didn't catch that earlier, but welcome, guys. So we're going to start with our visitors with us today. Delegate Szeliga, if you could start, and Delegate Johnson, you will follow, and then I'll get to the vets of the committee.
Thank you, Mr. Chair, and thanks for the opportunity to be here and hear this important bill. Delegate Valderrama, have you made any consideration for testing? You know, that it's difficult. I am a small business owner in construction, and this, you know, is an ongoing concern with people. As I look at the testimony that was offered within that industry, especially, you know,
Very welcome.
there isn't currently a test.
I'm sorry, can someone
available.
mute? Okay.
Hold on, guys. Yeah, we're hearing a background noise, and You can't whisper. It's picking up everything. I'm sorry, Delegate, please continue.
Sorry,
Thank
Kat.
you.
Delegates
That's all
Jordan.
right. Thanks. You know, that the concern about testing employees, you know, generally, you know, speaking, what they do after work or recreation or medication is separate from what happens on the workplace. And, you know, workplace concerns about people who are using marijuana while on a job site, such as one that involves power tools and heavy equipment.
I can say as the sponsor, I am open to that, but I can also answer by saying, and you will be hearing from one of our lead panelists who is a construction, the right title for his position, who was injured on a construction site project. We are open to listening to offerings of amendments that would help move this legislation forward. But in answer to the question, yes, open to negotiation and discussion. But I think your question might be answered after hearing from the lead panelist, Mr. Shepherd.
Thank you.
Is that helpful? Okay.
Delegate Johnson.
Thank you, Mr. Chairman, and thank you, committee, for having us as guests today.
We are open to listening to offerings of
Delegate
amendments that would help
Valderrama,
move this legislation forward.
My
But
wife and I
in
own
answer to
a
your question,
pharmacy.
yes, open
Hold
to
on.
negotiation and discussion.
Hold on.
But
Steve,
I
Delegate
think
Johnson, hold
your
on.
question
Somebody's,
might be answered after hearing.
we
from
need, whoever's listening
Bob.
to it over
Thank you.
YouTube.
It's playing back with my testimony.
Right, that they're listening to it over the YouTube, what
Oh, got it.
and it's behind us. Guys, we have to keep the phones on if you're not talking. We're getting all sorts of feedback and it's not being fair to those who are speaking. So please keep your phone on mute if you're not speaking. Delegate Johnson, I apologize.
That's okay. We're all trying to work through this virtual world. So thank you, Mr. Chairman. Delegate Valderrama, my wife and I own a pharmacy, and we have seen, since people have been able to get medical cannabis, the decline in some of those customers that were on opioids. They've been able to wean themselves down, and some of them even off of opioids. So have you reached out to the Pharmacy Association to get their way in on this?
You're on mute.
Delegate Valderrama.
How did I mute myself? In any event, sorry, Delegate Johnson. I have not heard from the Pharmacy Association. I have not reached out, nor have I heard back from the Pharmacy Association, whether in support or opposition, but I'm happy to do that as well.
Thank you, Mr. Chairman. Thank you, Delegate.
Thank you, Delegate Wilson and Delegate Howard.
Thank you. Delegate Valderrama, a few quick questions, because the medical cannabis, that's not currently, I mean, anybody who knows anything about it, it's not difficult to get a prescription. They actually have signs in the middle of the roadways every weekend and on the side of the road saying how easy it is to get a medical marijuana prescription.
Really?
But
Where do you drive? I don't see those.
Through Prince George's County mostly. So, you know, no, I'm just playing. It's literally all over the place. My county included. It's literally in the middle of the roadways, on the side of the roadways every weekend. There are signs everywhere. Get a number, medical marijuana, and a number. That's not difficult. So my question really gets down to, would these treatments include treatments for anxiety or sleep loss, insomnia, headaches, post-traumatic stress, and eating disorders? Would that fall in line if someone says, because of something that happened to me at work, I now have an eating disorder, or I now have insomnia? Will they also now be able to force their company to pay for their insomnia treatment or their eating disorder treatment or their sleep loss? I guess insomnia, sleep loss, apologize. And if so, is there a term limit, or is this now a lifestyle?
Okay, first part of your question, that is not the intent of the legislation. It's already, what we're trying to do is just add the written certification of a physician for medical cannabis. So in current statute with workers' comp benefits now, for the injuries that are received or acquired from their accidental injury, I should say, we're simply trying to codify and add to current law now with let me pull up the bill, but you should have the bill in front of you.
I've got the bill.
Final- Right, so it's just to add the fine language that you see amended on there.
Right, and I get it, but my
But
question.
it's for those physical injuries that are acquired. So, I mean, if there's language that we can tighten, that needs to, but it's not for the examples that you just suggested or provided.
That was what I wanted to ask, because there are also mental illnesses, and we see it a lot of time, especially in police officers. Whenever they're in a high-speed chase or something of that nature, they will submit something for post-traumatic stress disorder treatment and pay. And obviously, and I've done a little of this work, it escalates the amount of payout, because now we have to treat that illness as well as the insomnia that's caused or things of that nature. And I just worried that we're really opening this up for lawyers to just expound and, take more money. But in the term, from what I've understood, because again, it is not difficult to get a doctor to sign off on a medical marijuana card. What would the term of treatment be laid out, or is that just, like I said, is it now a lifestyle that the employer must supplement?
In my personal opinion, it would be a term of the latter, that not a lifestyle.
Okay, because a lot of times, again, it's just a card. You have a card that I don't know about the express. You get the card. It's, again, my worry is it's not hard to get the card. It's not hard to get a doctor to sign off, and they'll do it infinitum. So once you get your card, and it's not hard to pay a doctor to get you another card or resubmit. I'm just worried that we're not going to have our employers paying for a, potential habit for an individual versus treatment. And I don't see anything in the bill that would preclude that.
Again, so just to be clear, I would not sponsor a bill that would incite a lifestyle for this, what you just laid out. And again, we have a panel who, could cover in more detail and specific.
Okay, that's fine. I'll wait. Thank you.
Yeah.
Delegate Howard and then Delegate Walker take the last question of the sponsor so we can get to the witnesses.
Thanks, Mr. Chair. Delegate Valderrama, what did you have in mind? I think it's pretty clear when it says certifying, physician, but what did you, written instructions of a physician, but who did you have in mind? This goes to more to CT's question, I guess, as certifying provider, because that seems very wide to me. And on Route 2 South through Edgewater, you can come down anytime. There are rows of little yard signs. We all know what those are. And they all say like, hey, need a pot card, give me a call. And it's a running joke in some of the circles, quite frankly, with, some of the kids I know in the area about, hey, it hurts when I do this. Well, okay, you need a pot card. I mean, did you feel that? I test your reflex. Oh, well, you need a pot card. I mean, it's quite frankly, seriously, some of the kids that I know down there through my daughter and kids that she knows and things like that, they laugh about it, about how easy it is. And one of my concerns is that, it's very broad to me, at least. I understand physician, and I think that's really the direction that you're trying to go. But one of my concerns, certifying provider is a little wide. And have you reached out? There are clearances. Now, a lot of those things would fall under federal purview, but there are also jobs in this state, air traffic controllers. I used to work at Calvert Cliffs has got their own little forces. I was with them. This would supersede some of those jobs that are incredibly critical. And I certainly don't want people, to be high in any way, shape, or form. And we've done a lot of tests. They've shown that there's lingering effects of some of this stuff, and there's some real serious decision makers out there. And I just wanted to know a little bit of your feedback about that.
Okay, so I'll try to encompass
2 in 1. Sorry, Chris.
Yeah. Let me start by saying, again, I'm just going to repeat, I've not seen these signs that everyone seems to be seeing, and I live in Prince George's County, but thank you for the heads up. I am not, you understand my intent. It is.
Yeah.
We can, again, to narrow the language, whatever we need to do, provider, well, clearly provider is not something I can see the members are not with. So I get that. And also, I just want to say, so again, the intent of this legislation is to add to current statute already, right, to add medicinal cannabis, because right now, I mentioned in my testimony that it's opioids and people are getting addicted. And quite frankly, one of the lead panelists who you'll hear from, the opioids, no, I've never taken an opioid, so I can't speak. I don't do weed, so I can't speak on that behalf either. But from what I understand with opioids, it's really draining both mentally and physically, and it's not doing the job that no one wants to be high. Okay, so let me just clarify. I also know other issues that were brought up that you may have mentioned, or unless I'm just putting it in there now. Everyone, I know the issues, employees being high or, out of it. Right now, if someone were taking opioids, you're instructed by your physician, the provider, whoever gave it to you, that you're not to, people do what they do, right? So it's not any different when I say, when you're prescribed opioids or whatever the drugs are that you're prescribed, you're not to work with machinery, you're not to drive, you're not to do, major things that could cause injury to yourself while under quote unquote the influence. So again, the whole intent of this bill is just to add the term medicinal cannabis as an option for patients who are suffering from their severe injuries. And a lot of them are lifelong injuries. So I don't know if that answers your question, but happy
we'll
to,
talk, but I mean, I get it. I know what you're trying to do. And I think there are some benefits here. It just, to me, I understand, Chris, I totally understand what you're trying to do. And these people's suffering is not lost on anybody. And you know that, but when you're talking about like machinery and opioids, I think those are 8 and 12 and 24 hours. There's test after out there where they've done blind studies on pilots and simulators where they've had, somebody that hasn't done it, and then they have versus somebody that does, even 2 weeks later, they have a slower reaction time. So we'll talk. But yeah.
And again, there's an attorney and a nurse practitioner, I believe, who can answer, again, in more specificity to a lot of the questions that's probably out there waiting or that have already been asked. So,
right. Thanks, Delegate Valderrama. Thank you, Mr. Chair.
Sure. Did I leave anybody out?
Yeah, man.
Delegate Walker.
Sorry. Thank you. I think the last question was close to what I'm trying to get at. I'm trying to read the bill and I'm not understanding it. So I'm just going to try to make sure I'm getting this right. So for somebody that's on workers' compensation right now with an injury, they are not eligible to receive cannabis. Is that correct? And this is Bill's trying to say it will allow them to do it.
Yes, that the employer or the insurance provider of that employer. Correct.
Call him. And then that's why, so the question becomes, then I'm going to go along with Delegate Wilson, like, is there a term for it? Like when they get the workers' comp, is it while they're on workers' compensation, while they're out or away, or is this indefinite?
It's to be a while on workers' comp. And if I answered that incorrectly, I don't think I did, but if I have,
okay, so
someone will correct me, but yes.
So if it says I'm out for 6 months on the job, then I can use cannabis.
Yes.
Okay, yeah, that one there, I'm gonna say it makes a lot of sense. I know what you're trying to do, because when I played in the NFL, there were guys that felt like they were getting turned into junkies because they had to do
right.
And oxygen. They hated, they would get fined, and they said all we needed was some weed or something. Right. So
no, thank you, Delegate Walker. And the next panelist is someone who has been on opioids for a long time. It just was too much on his body, and all he needed was the medicinal marijuana. So.
All right. Thank you. Thank you, Mr. Chair.
Mr. Chair, I have a brief follow-up to with Delegate Walker. It'll take 2 seconds.
Go.
Delegate Valderrama, just wanted for clarification. This bill isn't this is not allowing them to smoke marijuana or take marijuana. They're already allowed to do that under law. This just forces the employer to pay for it. From what I'm reading, it's not about what they're allowed to do. They can do it. They might have to do it out of pocket. They can smoke marijuana. This bill just requires the employer to pay for it. Even the gentleman who's on, like you said, a lifetime amount, that would be the employer's job, correct?
Right.
Thank you.
So, Mr. Chair, may I ask a question on that?
Hold on, guys. We can't turn this into a debate. But I'll let you finish, Delegate Walker, and then I'll get to the witness list.
Yeah, because it helps for the clarity I'm trying to get. So, right, I guess it comes down to, so as an employer, I would be responsible for paying for my employees'
So right now in the bill, it says employer or employer's insurance provider. So the insurance provider,
So the insurance company would pay for it.
yes.
Okay. All right, thank you.
And
Alrighty.
again, if my panel is there, if I answered anything incorrectly, please correct me, but I don't think I did.
Okay, Delegate Valderrama, it's not listed in any particular order.
Okay, well, Mr. Aaron Shepard is to be the lead.
Okay,
Yes, I can see him.
Aaron Shepard.
Thank you, Mr. Chair. I am here in support of House Bill 683 because this has had a direct impact on me in several ways, and I do not want to see it happen to other Marylanders. As you will find in my written testimony, I personally suffered from opioid addiction from 2002 to 2006. This addiction stemmed from a series of knee surgeries that took place up until 2005. This cost me my marriage, custody of my daughter, and almost took my life in 2006 before I got clean. In January of 2020, I suffered from a 10-foot fall at work. I fell on my back, which left me with 2 severely fractured vertebrae. I was flown to Washington MedStar, where I spent the first 2 weeks of this journey. The very first thing they did was start me on a drip of Dilaudid, followed by morphine. With my past addiction, I feared the medicine more than my injuries, and I knew immediately that I was up against 2 separate battles. It took several close friends to convince me that I needed to take the opioids because the pain was intolerable. Once I was released, I did everything possible not to use the opioids, but was finding myself financially struggling with the amount of money spent on medical cannabis. I did continue on using the opioids for this reason. In November, I went on to receive surgery, which left me with 8 screws and 2 rods in my back. Again, very strong opioids were needed for the first month. After I was able to better manage the pain, I began treating myself with only cannabis, as I am a certified patient and could no longer deal with the side effects of the pills. I no longer take any pharmaceuticals. Not only does cannabis keep my pain tolerable, but has also significantly helped with my healing. There are proven studies that cannabis promotes bone growth, contains anti-inflammatory agents, combats pain, and many other beneficial properties. In Maryland, cannabis is deemed medicine. What's troubling to myself and many other injured workers is that we have access to deadly opioids at no cost when we are willing to use a safer legal alternative. I choose my health, which is costing me dearly. There is precedent set in other states involving reimbursement through workers' compensation. Recently in New Jersey, an appeal was ruled on in January 2020. This decision stated that the original ruling to allow reimbursement did not conflict with the Federal Controlled Substance Act, which states that marijuana cannot be in possession, manufactured, or distributed. The ruling upheld the original decision because it did not direct the insurance company to commit any of these offenses. Furthermore, all entities within a medical cannabis state are currently protected under the Rohrabacher-Farr Amendment, which was just renewed in December 2020. This prevents the Department of Justice from going after any entity that is within state medical cannabis laws. This amendment has been active since 2014. I am very grateful to share my story with you. For the reasons I've stated, I am urging you to pass House Bill 683. This is a very necessary tool to help combat the opioid crisis in Maryland and give injured workers like myself a safe alternative. Thank you.
Any questions for Mr. Shepard? Seeing none. Jump in if I miss you, if I happen to miss you guys.
I was just going to say, I highly encourage someone to ask him a question because he has all the answers that, if anyone, if none, okay.
Olga Hall,
Mr. Chair, I'm sorry, I did have a question.
Delegate Walker.
Hi, thank you, Mr. Chair. Thank you, Mr. Shepard, for your testimony. After, let's suppose, I'm still trying to wrap. So somebody, you've got it for workers' comp for 6 months, and then you're on the painkillers, and then you get addicted to painkillers. Once you start using marijuana to ease the pain and suffering, is there a time frame in which you should be allowed to use it, or is that something that goes on infinity? As long, like, you know, we want people to get off of prescription drugs, and then they want to use, at a certain point, does the cannabis become recreational as compared to for previous addiction?
I would say that would be up to the certifying provider, which, by the way, certifying providers can't just be anybody. They have to have a medical license. And you do have to get renewed by your certifying provider every year. So I would say it would entirely be up to your certifying provider whether you get renewed or not.
All right, thank you.
All right. Delegate Watson.
Thank you, Mr. Chair. I'd like to ask the gentleman that just testified if I have this correct. So what we're saying is that treatment with cannabis would be compensable by the Workers' Compensation Commission, which would require the insurance company to pay for it. Is that correct?
The way it works, because of federal law, as a patient, you have to pay with cash. So you would have to obtain a receipt. Yeah, you would have to obtain a receipt and then submit that to the workers' compensation company, and then they would reimburse from there.
Right, but the treatment would be sanctioned by the Workers' Compensation Commission, which would require the insurance companies to pay for it, but they couldn't pay for it directly. They would only be able to reimburse it because of the problem with cash.
Correct. For now, I mean.
Second question is, if you're being treated regularly with cannabis for pain or whatever, isn't it true that you develop a tolerance for it, which requires more and more?
Thank you. Bye-bye.
Which requires more and more of the cannabis to treat the same amount of pain. If so, it escalates the cost.
My answer to that would be yes, but the more you take, your tolerance goes up, which also means the more you take, which also means the more chance of death that could come about with that. Once your tolerance goes up with cannabis, you're still receiving the benefits. Medical cannabis patients don't use cannabis to get high. We're using it for the benefits that they provide, which there's a ton of research out there that lists all the benefits.
I think you said
that would be my answer.
Okay, I just want to make sure you said your first statement, you said cannabis twice, but you were talking about opioids in your first statement then, where you said that opioids has increasing tolerance as well.
That's correct. With cannabis, your tolerance does go up. But in comparison with opioids, your tolerance goes up as well, which means you're taking more opioids as well also, which puts you at more of a risk than
which you can die from, where you can't die from that with cannabis.
That's correct. That's
okay.
Correct.
Thank you so much. Thank you, Mr. Chair.
You're welcome.
Delegate Ahrens.
Thank you, Mr. Chair. Mr. Shepherd, aren't there FDA-approved drugs that imitate cannabis?
That's kind of out of my realm. I'm sure that they have some out. Yes.
Okay. I was just wondering if why we wouldn't be prescribing those, which would probably ease your pain and do a lot for you on that side. That's all. Thank you, Mr. Chair.
My answer would be because the state of Maryland has passed law that we have a medical cannabis program, and it has been deemed medicine in the state of Maryland.
Okay, but okay, I'll go back to another thing. You mentioned earlier about this professional that will approve this. Is that the same professional that would approve me getting on medical marijuana?
I'm sorry, I didn't hear the first part of the question.
Would the same doctor that would approve me getting on medical marijuana that I see when I go up to a dispensary, would that be the same doctor that you're looking to approve this for workers' comp? Could it be?
It could be, sure. Yeah, any physician can sign up through the MMCC, and they do have to go through a process that allows them to provide medical cannabis in the state of Maryland.
I guess my concern would be is I've been to a dispensary and I've been, approached to where I could get it myself personally. And it's a matter of, well, what's wrong with you? I said, my shoulder hurts. Well, I can find your doctor will prescribe it for you. So that's a concern I would have with the bill, but thank you.
Yeah, you're welcome.
Am I missing anybody? Delegate Mouts?
Thanks, Chairman. I've got a quick question. And with the way the bill works and the use of medical cannabis, would there be any restriction on the type of medical cannabis? We're talking about a government mandate and we get into smoking and things like that. And I know medical cannabis comes in different forms. Mr. Shepherd, is there, have you, in working with Delegate Valderrama on the bill, is there any discussion about, smoking versus the non-smoking forms and things like that?
Yes, again, the provider, once you get certified through your provider, they go over everything that you need to know that will help you with what you're experiencing, my pain. But also in the state of Maryland, the dispensaries now have clinical directors in every dispensary. Those clinical directors are instructed to, their job duty basically is to explain to patients the different strains, the different strengths, different ways to use cannabis. And they also, their responsibility is to teach the dispensary agents when they dispense to explain the same type of things. So it's not really just a free for all. You are receiving instructions twice, really.
Right.
At least twice.
Yeah, but if there were a restriction against, say, the smoking cannabis versus the tablet or the drops or whatever, that wouldn't make a difference to you, would it?
Well, again, it's already in state law. It's already defined. Like personally, I can't go out in public and smoke cannabis. It's illegal. I'll receive a citation or more. So there's already definitions in state law that covers those issues. But again, I wouldn't have a problem with that because there is other ways to medicate that actually some are more beneficial.
Thanks for answering my question.
You're welcome. Thank you.
Delegate Johnson.
Thank you, Mr. Chairman. And whoever's best suited to answer this question, how is this going to work with federal employers?
That'd probably be a better question for the attorney that's going to be testifying here shortly. But again, right now,
well, we'll let him answer that then. Thank you.
Delegate Watson, did you have a follow-up or was your hand left over?
Sorry about that.
No problem. Mr. Shepherd, can I ask you a quick question? Hopefully it's a quick question. I know you said it's for pain management, and I know the purpose isn't to get high. How does it help though with pain management? Exactly what is it doing?
It's basically working sort of like an opioid. It works on your CB receptors, which again, I'm not a healthcare provider, so I can't really explain exactly. But like I could say with me, once I use cannabis, I don't, because my tolerance is high, I don't get high. I feel my pain.
Let me stop you right there. Let me back up. When you first started taking it,
sure,
did it get you high? And I'm not on this about the high part, but I'm just asking that the other benefits aside, did you have some sort of mind altering? I mean, did it have a high effect?
Sure. And in the beginning it did, and even sometimes now it does. But again, that kind of goes away in a short amount of time. Basically an hour or two, where opioids, you're feeling loopy for hours. Yeah.
No, I'm following you.
But it's more than just pain for me. It also has, anti-inflammatory properties. I have a depression issue as well. I've lost both my parents to cancer in the last 10 years. So it helps me with that as well. And I've learned to, as do most patients in the state of Maryland, I've learned how to medicate myself and how to use the certain terpenes and cannabinoids that are in cannabis to treat, certain issues. And there's plenty of research out there that allows you to do that. And most patients that I know in the state of Maryland do take that measure.
Got you. Thank you very much. This is new to me.
Thank you.
I appreciate the insight.
Thank you, Mr. Chair.
Further questions for Mr. Shepherd? I'd like to go to Olga Hall.
Hi.
Hello.
My name is Olga Hall. I'm a RN, BSN case manager, cannabis nurse in Maryland. I did want to speak to one thing that everybody kept, before I even start, everybody keeps bringing up. I want to speak to the length of time that a prescriber would put someone on cannabis. So cannabis, the people that are recommending cannabis, I understand that everybody is worried, that anybody can get on cannabis. The person that does the cannabis recommendations is not the same person that is doing the diagnosing. The person that does the diagnosing would be the person that makes a determine about whether or not this person needs to continue on medical cannabis. The person that does the certification, they don't do diagnostics, okay? They just say, okay, this is your diagnosis, so yes, you are eligible for medical cannabis. That's it. Workers' comp isn't even really gonna mess with that doctor. The doctor they're really gonna talk to is the orthopedic surgeon or whoever it is that actually made the diagnosis, because I repeat again, cannabis physicians do not diagnose. All they do is make sure that the diagnosis is matches and that they're able to use that diagnosis to get a cannabis certification. I just wanted to make that clear. Thank you again for letting me testify. When a person is injured at work, they're more likely to be prescribed opioids right now as treatment. Long-term use of opioids creates an unsafe environment where medical prescribers are prescribing excessively high and higher doses of opioids, sedatives, and muscle relaxers, and then keeping these claimants on those drugs well beyond the initial injury or surgery period, which then extends the time that they have to stay on workers' comp. The US is also in the midst of an opioid epidemic right now. There is a relevant ruling from back in 2007 where a worker was injured and he injured his back and was treated for 5 years until he was found dead in his bed with a box of fentanyl patches in his hand. The daughter filed a claim against the Pennsylvania Workers' Compensation, and she actually she won the claim because they found that employer was still responsible for that worker's death through workers' comp because they were taking fentanyl and they overdosed on fentanyl. Also, the annual cannabis industry report states that the average medical marijuana user spends about $136 every 10 days. The average 30-day cost for one single opioid is average $251. Analgesics, NSAIDs is another $100. Muscle relaxers is another $150. So if you're on 3 medications, you're already looking at close to $700-800 a month, which is far more than what you're presumably would be more than what you would be spending. Some of those pain medications can be really, really high, really expensive. And then since cannabis has the same benefits as all of those pharmaceuticals, you're looking at using cannabis for more than one purpose. Like Aaron was saying, for anxiety, depression, things like that.
Ms. Hall.
Yes.
Are you there? Again, it's similar to the question I asked, or maybe identical to the question I asked Mr. Shepherd. How does cannabis help? What does it do for someone who's on it? And does it have a sort of a high kind of thing? I understand that's not the purpose of the bill, and that's not where I'm going with this, but I do want to know how does it benefit? Not what the benefits are, but how does it benefit? What does it do to relieve pain?
You mean in the body? Like, how does it work in the body?
Yes.
So it reduces inflammation of any joints. If you're having surgery, it helps promote post-wound healing. It has antibacterial properties to it. A lot of different strains have terpenes with antibacterial properties to it. There's CBD, if you're adding CBD to certain things, CBD can treat breathing disorders. So for people that have had like inhalant accidents or exposed to fire. If you're looking at mood disorders, there's almost no mood like that. It helps balance out the brain chemicals like antidepressant would.
No, I got you. That's the best I think I've heard with all of this. That gave me, I mean, before this, just an explanation of exactly what it does. But it does, would you say, as I think Mr. Shepherd alluded to at the beginning, for someone at least when they first get on it, it would have a high effect?
I mean, it depends on how you're using and what you're using. So like if you're taking a CBD, a high CBD, low THC, which is what a lot of people use during the workday, no, you're not going to get high on that. That's just going to give you those medical benefits. But it's still going to give you your pain relief and all that. But you're not going to get that alteredness that, that head high.
So the type, when you're getting for medical, it should be the kind you just described, or it can go either way?
Because we're treating so many things with cannabis, you can get any kind of cannabis, you know what I mean? So you can't really restrict what somebody is using because each person uses what works for them. It's highly individualized. I heard somebody say that there's medications on the market. There is absolutely not any medication on the market that works like cannabis. None.
Got it.
There's one medication that's called Epidiolex. It is specifically a seizure preparation for children. It is not it's a CBD isolate, which means it's one isolated component of cannabis. It's not whole plant medicine. That absolutely only is for epileptic children. That's the only cannabinoid-based medication on the market.
I thank you very much for your answers. Delegate Pippy, Delegate Wilson, and then Delegate Walker.
Thank you, Mr. Chair. I guess this is for the last speaker. Just try to match kind of her testimony with the previous speaker's testimony. One thing that I heard was that the concern with, let's say, an opioid medication would be that you could build a tolerance, therefore it would increase the amount taken and would prolong costs and time on workers' comp.
Right.
Obviously, we heard that exact same story, from the first speaker with cannabis, which is you're going to build a tolerance, you're going to have to take more. You could argue that it could prolong and more costs on workers' comp. I think the difference was that you said it was less expensive overall. The amount, the doses.
Actually, the difference is I guess, so the same as with the pain medication is the same as with cannabis. When the orthopedic doctor decides that patient doesn't need to be on pain medication anymore, then workers' comp doesn't have to pay for it anymore. It's not a matter of going to a cannabis doctor and the cannabis doctor saying you can keep renewing your certification. The patient can do that. But the orthopedic surgeon would be the one to say you do or you don't need this pain medication. So it's one. And two, it doesn't work exactly the same. So you are going up in your usage, but the difference is you can also switch usage methods. And you can also take tolerance breaks. So there's things that can be done with cannabis to keep your usage kind of even keel, whereas pain medication doesn't really work that way.
And my quick second point was that I've worked a lot on different opioid things with folks and people that have with some recovery centers in my jurisdiction. And one of the things that we heard a lot was that, especially with heroin and other more serious types of drugs, is that they're kind of chasing that original high, that they're not really getting high anymore. And so we heard this testimony that, people that are taking cannabis medication are not getting high and this and that. But a lot of people would argue, folks that have done a lot of heroin, they're not getting high either. In most cases, they're trying to get rid of the symptoms of withdrawal. So they've been on heroin, they have severe symptoms of withdrawal, and in many cases, they're just continuing to use because the withdrawal symptoms are so severe. And I'm not saying they're not getting high. What I'm saying is that, there is a correlation between a lot of these things. And I think to the chair's point, in the beginning, a lot of these medications, whether it's medication, cannabis, heroin, whatnot, there is a high. And that tends to kind of dissipate over time, and individuals, may keep using it, may not feel the same, but there is a concern there. So that's all I have. Thank you.
Delegate Wilson.
Thank you, Mr. Chair. Is it Dr. Reed Hall? Is that correct?
Oh, just Olga is fine. Olga.
I'm not trying to catch you up. I just didn't want to be wrong. And I appreciate some of the insight you provided. So I wanted to just go back. So one of the issues I had was the infinitum. I've got a lot of friends who have marijuana cards.
Yeah.
And they got them really easily.
Oh, yeah.
My worry was the employer. So we're not here to discuss, that. My worry is the employer having to pay like forever, but you're stating that on a regular basis, they come back in and they reevaluate the validity of this individual's pain and suffering as to whether they'll keep paying for the marijuana, correct?
So that's just an insurance fact.
Sure, and that's fine.
The medical marijuana providers aren't diagnosing, period. So they can absolutely not make any recommendation to any insurance company about anything. They're only there to provide the card. The actual recommendation for how to use it, what they should be using, and how long it'll be used will be made by the doctor that diagnosed the patient with whatever it is. So whatever doctor that workers' comp sent them to, they'll let that doctor know, you know what, I would like to use medical marijuana instead of pain meds. And
so for my buddy who has insomnia and he goes to one of these doctors, literally that he found on the side of the road, and the doctor says, well, you do have insomnia. That doctor would not be used by the workers' comp board, correct?
Right. That would just be the doctor that the patient used to get the card.
Right. So that you're saying that the doctor is basically referred by the medical workers' comp board. Absolutely. I can't just go out and pick my doctor to tell me that I've got insomnia, that I've got post-traumatic stress, or that I have, what has it been? Glaucoma. Exactly. So all those things basically come through this is very important.
Yeah, because I know that's what I was trying to get across to everybody. I worked for workers' comp. I worked for several different workers' comp, including DC government workers' comp. They all have a panel of doctors that they use, period.
And
so those are the doctors that would be telling you, the doctors on their panel that they've chosen, those would be the doctors that would say, yeah, this patient, still needs their medical marijuana, or no, this patient shouldn't still be needing so much. Then workers' comp doesn't have to pay anymore. The patient can still go get their medical cannabis, but workers' comp doesn't have to pay anymore.
That was my big sticking point. Lastly, I just want to get into this briefly because I've asked this question before. However, when we talk about post-traumatic stress, anxiety, things like those are, people consider those lifetime diagnoses, correct?
Yes.
So in cases like that, it may be a lifetime, pain.
That's very true. Because you might have been paying for, Prozac and things like that anyway, that, by the way, would cost way more.
No question.
Yeah.
Okay. I'm just trying to get to the basics, trying to figure out just the basics. Thank you very much, ma'am.
Never a problem.
Delegate Walker.
Thank you, Mr. Chair. Mr. Chair, do we have any actual medical doctors that are going to testify signed up? Will we hear from any?
I don't think so.
Okay. So I don't want to generalize this, but you can still go out, have the card, and you can go buy marijuana, to help your ease in pain and suffering. And I don't want to simplify it, but isn't that almost like when I get a recommendation from, say, my dentist to go buy some pills? A lot of times they give me the generic, and if I don't want my insurance covers the generic, but if I don't want the generic, I got to pay for the top of the line one. So I mean, in some way, isn't like, they're giving you something for the pain and suffering, but if you want to do marijuana, you just got to pay for it out of pocket.
I mean, what you're saying is if you want to take all the side effects of the narcotics and risk addiction, then yeah, you can do that, because narcotics and cannabis don't work the same. So you're comparing apples and oranges, really.
I'm not trying to. I'm just trying to figure
No. I get you. It's just it's not the same. It's not the same.
We all have our opinions on that. I respect
yours. No, but I mean,
too.
science says it's not the same. It's not an opinion.
So is marijuana? And I've always wrestled with this. I mean, you can get addicted to marijuana.
You can get addicted to anything. But it does not have the kind of, you're not the kind of addiction that you're thinking of with like heroin and stuff. No, not like that. It doesn't have that kind of addiction, and it does not have that death risk. It doesn't attach to the brainstem the way that those medications do.
And what's the longest term you've seen in your profession that you've seen somebody be prescribed prescription drugs? Like, do people, I don't know this, do people get like, okay, you're going to have, you get to take Oxy for years or
yes.
Is that
Actually, I have a
that?
patient, absolutely. I had a patient
Okay.
and I have several patients when I was working for DC Comp, car accidents, leg injuries, where not only were they on lifelong pain medication, but 10, 20 years in, we're then implanting pain pumps to give them IV medication around the clock. And then we're paying on top of that for the home health care to come in. And Comp is paying for all of this, paying for the pump, paying for the equipment, paying for the medication, and paying for the home health staff.
All right. Thank you. Sure.
Delegate Johnson.
Thank you, Mr. Chairman. I'm hearing, I want to make sure I get this straight. I'm hearing about insomnia and PSD. Now, would they be considered illnesses or work-related injuries?
Insomnia, I've never seen a claim accepted for insomnia, but PTSD, absolutely. That could absolutely be a workplace all the time, actually, workplace injury. And not just with service members, but with, anybody that was in any kind of traumatic accident.
So, but this bill would pertain strictly to work-related injuries, not illnesses, correct?
Right. This is just workplace injuries. Yes.
Thank you. Thank you.
Delegate Charkoudian.
Thank you, Mr. Chair. I just wanted to clarify, Ms. Reed Hall, you're a nurse practitioner, is that right?
I'm a nurse, just a registered nurse.
So we do have a medical professional in this conversation. I know there was a question about physicians, but I just wanted to make sure. Sometimes we have so many people coming through here, we lose track of who has what. It sounds like you do have the qualifications to speak as a medical professional and a scientist with a science background. Is that right?
Yes, ma'am. Thank you.
Okay, good. Thank you. So with that in mind, I'm just wondering, the choice that I'm seeing in front of us, and I want to make sure that I understand this right. We've already made a choice in this state that workers' comp will cover opioids. And we've seen sort of all of what that means to cover opioids. Certainly some benefit from a pain reduction perspective, but massive risks from a individual health, as well as a societal health, as well as societal cost in terms of the people we've lost and the cost of addiction, right? Yeah. So now the question in front of us isn't, do we cover things that potentially lead people to want more of them, but do we cover one thing that has these massive side effects implications for our society, or something else that maybe people will have an increased tolerance, but it seems like the science of the two of them are so vastly different. And I just wonder if I'm struggling with the fact that I understand the federal rules and the history of this country and why cannabis has kind of gotten what it is. But I'm just trying to make sure we're clear about the science of what it is we're currently willing to have workers' comp pay for, and what it is we're saying right now we don't have workers' comp pay for, and we're considering having it paid for, and the science of the two of them next to each other. I'm not a scientist. I play one on TV. No, I try to understand that piece of it. I'm just wondering if you can, and you sort of have already, but if you could just walk through the science in terms of what each one does to our bodies, what each one does to our, to the possibility of what the implications are in both cases. If our tolerance goes down and we need more, what the implications of each are compared to the other. And then finally, there was this question earlier, sorry to stack all the questions, but there was the question earlier that was being asked to the delegate and to Mr. Shepard, about like, what if someone's working construction? And I guess I'm wondering, similarly, if you compare them, if someone has to take opioids on a regular basis for pain, what the side effects implications are with heavy machinery, what the guidance would be. If somebody is similarly taking medical cannabis for pain, what the side effects or what would happen if they're also, potentially working construction or some other sort of heavy machinery. Is that okay? Is that too many?
Oh, no, that's great. Actually, I'll start with that part because that's the easiest one. I actually saw that come up in DC where they had somebody that was working for the Department of Public Works, and they said that she couldn't do it, and they ended up changing their mind and allowing the woman to have her medical cannabis. What the middle road was that she was expected to submit a care plan. So she was expected to submit to her employer, the plan of care, what she was doing. Okay, this, I'm on these medications in the morning and I'm on these medications in the evening, and I'm not taking, and the doctor had signed off on that, and that worked out well. I'm trying to remember the other questions. Oh yes, as speaking to how cannabis affects the body versus how opioids affect the body. So both of them, the risk of addiction that you're talking about with that, or with any other thing like gambling, for example, when you gamble and you get that dopamine hit, and that's what causes the addiction because people are chasing that dopamine hit. Cannabis doesn't work the same way as the opioids that way. So opioids, you get a fast heart because they are so similar to heroin. They are so similar to street drugs. They're chemical. So the dopamine hits that you're getting from those are harder. And when they go down, you're left with almost no dopamine. So you're craving that next hit. You're chasing that next hit because you really, really need it. As opposed to cannabis does give you a dopamine hit, but it's considerably lower, and it also boosts the rest of your brain chemicals because cannabis isn't something created in a lab. It's something that grows out of the ground. It's something that's meant to work with your body. So it boosts all of your brain chemicals and keeps them there. This is why it helps with depression and anxiety. This is why it's able to help with, you have a lot of these same receptors, dopamine receptors and serotonin receptors all through your body. So it's able to help with your GI tract. It's able to help, women with female problems. It's able to help with all kinds of different things because we actually have receptors in our body that work directly with the chemicals in cannabis. Whereas opioids just don't do that. They work on one receptor, and then, like I said, they just make that dopamine go up. So when the dopamine is really high, you don't feel anything except the high. The high that you're concerned with cannabis, I promise you, patients are getting far higher on morphine. Patients are getting far higher on oxycodone. That's where your high is. And that's why people are throwing their lives away to chase that down. It is an intense, fast high, but it doesn't last long. A lot of people are able to we're using cannabis right now at a clinic that I work at in the district. We're using cannabis for harm reduction to take patients off of opioids because they still have their high, but it's safe. It works with all the brain chemicals. It brings them out of that depressive state. It brings them out of that anxious state. So they're able to stop using the hard drugs or even the prescription drugs and just transition over to cannabis. And then we transition all the way off.
Thank you. I appreciate that. Thank you, Mr. Chairman.
Is that everyone? If so, Jason Plotkin.
Chairman, Delegate Valderrama, and esteemed delegates, thank you for providing me the opportunity to testify today. My name is Jason Plotkin. I am the CEO of the Pinder Plotkin legal team. We are a law firm that represents injured workers, and we're also investigating opioid injury claims by individuals overprescribed by medical providers and pharmacists. I am testifying in support of medical cannabis as a workers' compensation benefit. It's an alternative to the opioid usage that can cause devastating side effects discussed here today. I have seen firsthand the toll long-term opioid usage takes on injured workers, hardworking men and women that work physically demanding jobs to make a living. They meet with me after being injured. Other than their injuries, many are in great physical and psychological states, easy to get healthy and get back to work. Unfortunately, many of these injured workers are prescribed opioids for pain relief. Those that are lucky recover quickly and stop taking opioids. Then there are those that are less fortunate. Those with significant lifetime pain-inducing injuries, they're left with few options to relieve pain and are typically prescribed opioids. So a lifetime of dependency begins. That dependency often leads to depression. There is some opposition to this bill that discusses the prescribing references to uncertainty of dosages and strains. strains of the medical cannabis. As a workers' compensation attorney, I can attest that there is uncertainty across the board when it comes to medical treatment, causation of injuries, or necessity of medical treatment, including opioid prescriptions, that result in hearings at the Workers' Compensation Commission several times a day. The parties present evidence, including medical records from licensed medical providers, orthopedic doctors, experts, and the commissioner weighs that evidence as well as testimony to make a decision. Point being, there are checks and balances that are there to protect a lot of the concerns that the delegates have expressed today. Medical cannabis should not be more restrictive than opioid prescriptions. There's also been some concerns raised about workers being injured as a result of their consumption of medical cannabis. Respectfully, those arguments can't see the forest through the trees. I am much more concerned about workers being injured through long-term opioid consumption. Long-term opioid consumption using heavy equipment, other things they can do to be a danger to those around them. I have observed these vibrant injured workers slowly wilt away to shells of themselves. They wilt as the dosage of opioids increases and the psychological effects and erode their lifestyle. Some of them go to inpatient rehab centers paid for by the employer insurer. That's the insurance company for the employer that actually pays for it. Some clients will have to go to rehab more than once because as you bring your dosage down in rehab, you're slowly bringing it back up as you continue to be prescribed opioids. Maryland has medical cannabis as a legal form of pain relief. The bill that we are discussing today codifies common sense. Medical cannabis is legal. Injured workers are prescribed large doses of opioids. The opioid epidemic is undeniable, and it should be made clear that injured workers have the right to use medical cannabis. Thank you for your consideration.
Delegate Johnson.
Thank you, Mr. Chairman. I asked the question a little while ago. I'd like to ask you, where does the federal employers fall in this? Because like a DOD contractor, they get their money from the federal government. So would this jeopardize them getting contracts, receiving federal funds? How does all that play out?
That is under a completely different set of statutes that are federal. That's through the Department of Labor, Occupational Health, that's outside of the state of Maryland. The state of Maryland workers' compensation law does not govern federal employees.
Okay, thank you.
No problem.
Anyone else? Delegate Watson.
Excuse me, Delegate, I think you're muted.
Sorry about that. Just to follow up on Delegate Johnson's question, suppose, and maybe this was part of the conversation earlier, but I don't remember. Suppose it was a local non-federal employer who didn't permit or had drug testing and didn't permit cannabis use. For example, a police department or even some of our trade unions, in their training programs do drug testing and they don't permit cannabis. Would we then, if they were injured on the job, allow them to take advantage of this if this bill passed? I mean, I guess we would, right? But then it would be in conflict with their employer's requirements.
Well, I'll answer it in more of a general, because that's going to be very specific to each employer's handbook and guidelines. That is the same guidelines and handbooks probably preclude operating heavy equipment on opioids. They probably preclude a lot of other activities. Usage of medical cannabis would be just like any other prescription. Whether or not it's tested for would be an employer decision. There could be each employer may have a system in place where if you're injured, you are doing a different position, or you might not even be allowed back to work, like a physical limitation you already have.
So basically what you're saying is the law, if we pass it as is, would apply, but it would be up to the employee to determine whether or not they would actually use that treatment, given that they know the employer doesn't permit cannabis use in some way, shape, or form.
Well, I would say this. I think there's probably other laws that would come into play as far as your concerns. Typically, when someone is injured and the insurance company works with the employer to see if they can return back to work while they're getting treatment, sometimes they're not able to because they have a modified or light duty based upon physical limitations. Sometimes it's because they're on or other medication that they can't go back and do their job for a period of time. So I think medical cannabis would be treated much in the same way.
No, you have
Sometimes clients are kept out of work while they're recovering because they can't go back to their same job. If they have a lifetime injury, same as in opioids, if they can't return to their same
this
job
is Kobe
because of
Little. I'm president of the NAACP.
Hold on. Mr. Little, I need you to mute yourself.
So if they are able to come back to work with medical cannabis, or not able to come back to work with medical cannabis, just like they couldn't come back to work possibly with opioids, there are provisions in the Maryland Workers' Compensation statutes to provide for suitable alternative employment through job replacement, where you'll go and to try to find a new career path, a new position. The goal is to find suitable alternative employment based upon their physical limitations, which could include medication use, opioids, medical cannabis, things along those lines.
Well, I would think it wouldn't. I would think that an employer that did not allow cannabis and did drug testing, and that was their policy, in their employee handbook, they would not create light duty position where an employee could use cannabis. But I mean, that's okay if if what we're trying to pass would allow for those individual employer decisions.
Correct. I don't see how it wouldn't.
Okay. And I just wanted to ask Delegate Valderrama why I've got this. This type of provision is now passed in other states. Is that correct?
5, yes.
5 other states. And is it passed in any other states with regard to non-work related injuries and health insurance companies? Do you know?
As I understand, if someone else wants to answer, but as I understand, they're all work-related injuries.
Okay. Thank you. Thank you, Mr. Chair.
Thank you. Delegate Howard.
Thank you, Mr. Chair. Hey, Delegate Valderrama, when you said 5 other states, when did it pass? If you don't know, that's fine. You can just.
I'd have to look that up.
Okay.
Unless someone here knows, but.
Yeah, I'm just trying to look and see if it was like 2 or 3 years ago and sort of see what the trajectory of it was and what roadblocks, if any, they hit along the way. And also too, Mr. Clocken, how would this affect, let's say, a Maryland-based employer working on a federal contract?
That would be governed by the contract as far as whether an employee could be using medical cannabis. Or there's probably, it would be based on the contract. If there's a drug test requirement in there, it could be opioids, could preclude that same injured worker from going back to that job site.
So if I was a union worker and I went on from a contract that did allow it to a contract that didn't allow it, I could basically be missing out on work. I guess is what I'm saying, just based on the outline of the contract.
Well, I can't speak to that because
the contract and what's that? I'm sorry.
I can't really speak to that specific contract, but if I could give you something similar, if you're injured and you have a physical limitation and you're a contractor, you might be on one job site able to do your job because the lifting is capped at, say, 15 pounds. You go to another job site and it's 20 pounds. That's outside your restriction. You can't go back to that job, and the insurance company has to help.
With all due respect, I mean, that's a lot different than what we're talking about here. And the federal government hasn't recognized any of this. And, you know, we have a lot of federal contracts and we have a lot of subcontractors to the subcontractor. We've passed many bills speaking to some of those issues. And what I'm trying to get at is how it would affect some of our workforce members, union and non-union, who would be going from a federal contract, even as a subcontractor, or a contractor to a federal contract from a Maryland-based business. I guess I said that a little backwards, but I guess what I'm trying to get at is that, and trying to see, and you're the attorney, so I'm asking you, is how it would affect someone that would be, for example, and I'm just trying to make it as clean and neat as possible, a union worker on a job that is a federal contracted job, you know, coming from a job that did allow marijuana usage, and now they're precluded from this other job that they could be at because of marijuana usage. I mean, I don't know. I don't know how you want to, if you want to.
Well, again, I think that would be specific to the actual contract, the contract language, what it requires, and the specific employer. They would have
So yes, they would be precluded from that work is what I'm getting at.
It would imagine so if the contract said they couldn't come, just like if they couldn't come if they were on opioids possible.
Well, opioids are federally recognized, and unlike marijuana, I mean, they're federally recognized as health treatment. Fortunate or unfortunate, that's to the argument today. Okay, thank you very much. Thank you, Mr. Chair.
All right. If there's no one else, I'd like to go to Mr. John Kelly.
He's muted.
Mr. Kelly, unmute yourself.
Mr. Kelly, you're still muted. I can see him trying to unmute, but
Tell you what.
there you go,
I
Mr. Kelly.
believe you can hear me now.
Yes.
Okay. My name's John Kelly. I'm an attorney. I've been practicing workers' compensation law for 45 years. I have a scenario that I lived with, probably, I know, the first medical marijuana approved order from the Workers' Compensation Commission. And I have a story to tell you about what occurred thereafter in regards to the employer. But I'd like to point something out to you that you haven't seemed to catch in all this, is the Workers' Compensation Commission would have to order the medical cannabis. It would have to be recommended by a medical doctor. It would then, the employer and insurer would contest it, and the Workers' Compensation Commission would have to find that the medical cannabis is a reasonable medication to take for the condition that the injured worker has related to their job. So as a result of that, you've got another level of people reviewing the prescription for the medical cannabis. It has to be fair, reasonable, and causally related to the workers' compensation injury. So as a result of that, you're going to have another layer of this as the right medicine to use for this person and that are injured. In the particular case I was going to tell you about, my client was injured in 2006, head-on auto collision driving his employer's automobile. The employer then, they put him on narcotics. He ended up with a back operation, ended up with a neck operation, and 6 knee operations on his bilateral knees. And he had chronic pain. And he was taking it, and also as part of the injuries he incurred, he suffered a traumatic brain injury in the accident. It was a head-on collision with another large truck. Thereafter, he went 11 years hooked on heavy-duty opiates. He reduced them down twice to what was called a moderate level of opioid use. He didn't like them because he was getting that up high and the down when they would wear off and everything. So he tried medical cannabis, and he used medical cannabis that he was paying for himself to begin with to wean off of the opioids. The opioids cost about 4 times as much as the medical cannabis did. And this is after he was 12 years on the opioids, on the narcotic pain medication. So as a result of that, it was a long time period, and he was able to wean himself off in about 2 months of all opioids. And he took mostly CBD oil, which has no THC in it, during the day. And he took the medical cannabis that has the THC in it. Most of that was taken at night so that he could sleep. And that allowed him to be able to sleep. But the story is, I got an order from the Workers' Compensation Commission that said that medical cannabis was a reasonable medicine to treat his condition. Then the insurer appealed that order when they were ordered to reimburse him. I think you ought to make it reimburse the claimant, because that will take some of the pressure off the insurer, the workers' comp insurer, because then they won't have the argument that they're procuring the drug for him, the medical cannabis, directly. But so then I spent a year and a half up on appeal, and the Circuit Court for Carroll County approved and said, yes, medical cannabis was a reasonable drug to use for his care and treatment. Then I went back and the commissioner issued the order again after the appeal. And again, the employer and the insurer
Mr. Kelly,
pay for it. Yes.
I've been letting you go on quite a while. We got to land the plane now.
Okay. Ask me any questions you want to.
All right. Delegate Aarons.
Yeah, thank you, Mr. Chair. Mr. Kelly, this board that you're talking about, the commission's board, is that going to be just comprised of regular doctors, or is there a special thing for marijuana? Would they have to have special training or special knowledge?
The board is the Workers' Compensation Commission, and they have special knowledge in regards to the medications and everything, because they have
marijuana is not a medication yet. Marijuana is not a medically approved. It's not a medication yet. What
it is a medication.
What's that?
You have the Medical Cannabis Commission.
Okay. Would they be part of this?
No, that's totally separate. Medical cannabis is a separate law on.
My confusion comes in on this thing where I understand that if I'm going to be put on opioids, somebody's going to have to approve the opioids, right?
Yes.
Through that, I'm just not sure of what qualifies them to approve medical cannabis if it's not really a prescription drug, if you will.
Well, medical cannabis, there is what's called a certification, and it is done through the Medical Cannabis Commission. It is not done through the Workers' Comp Commission. But what happens is you need to have a medical doctor who is treating the person for the injuries from the workers' comp accident. That medical doctor then says, yes, I believe this man's should be on medical cannabis. Then
okay. I got your point. Okay. Thank you very much. I appreciate it.
Okay.
Delegate Brooks.
Thank you, Mr. Chair. Mr. Kelly, when I checked that THC and medical cannabis is still considered a Schedule I drug. So what type of exposure would the patient be subjecting him or herself to, with that being the case?
Right now in the state of Maryland, the U.S. Attorney's Office is not prosecuting cases for possession of cannabis, and specifically has said they will not prosecute medical cannabis users.
Okay, all right. But if that person were to, say, go out of the state of Maryland and have that medication, so to say, then they would be subjected to whatever those particular laws are there?
If they took it out of the state of Maryland, you're absolutely correct.
All right. All right, thanks.
If that state has a law against the possession of cannabis.
Okay. Thanks, Mr. Chair.
Delegate Howard.
Thank you, Mr. Chair. Mr. Kelly, give me the 10-second breakdown just very quickly. A few moments ago, you mentioned reasonable. What were the other two?
It has to be fair, reasonable, and causally related to the workers' compensation injury.
Who decides that?
The Workers' Compensation Commission,
okay,
which is trained in those issues.
Okay, where do I go to see what they view as fair and reasonable? Because as we know in today's world, those have very stark realities and differences in realities for many people.
Well, you can talk to the head of the commission, Workers' Comp Commission, which is Mr. Allman.
Okay.
You can also talk to individual commissioners. But
So there's no
another layer. What I'm telling you is you have the treating doctor who recommends medical cannabis. You then have a certifying doctor from the Medical Cannabis Commission who certifies, yes, this man has the condition and he's entitled to it. And then you have the Workers' Comp Commission, which has to find that it's fair, reasonable, and causally related to the workers' compensation injury. In other words, you can't get it, as that nurse said before, because you're alleging that you have insomnia.
So there's no place that I could access freely outside of talking to members of the Workers' Comp Commission to see what standard they're using as fair, as far as the fair and reasonable is concerned.
Well, I think it depends on the nature of the injury. In other words, how severe the injury is, what the injury is.
So they would do it based on doctor's recommendations, essentially.
Right.
Is what you're saying.
Yes.
Mm-hmm. Thank you, Mr. Chair.
All right. Thank you all very much. James McAllister.
Yes, Mr. Chairman, can you hear me?
Yes, sir.
Okay, my name is Jim McAllister, and I'm a workers' compensation attorney. I've been doing claimants work for about 35 years. Let me just set the record straight in terms of how medical issues work at the commission, because I think the nurse who spoke earlier spoke of some sort of board of doctors. That's Washington, D.C. The way workers' compensation works in Maryland is the patient chooses his or her doctor. The doctor comes up with a plan of treatment. Then that's submitted to the workers' compensation insurance company. The workers' compensation insurance company then hires a doctor of its own. That's called an independent medical exam. Not a doctor who's independent, but a doctor who's independent of the patient. Or they have nurse case managers that look over these things, and they decide whether or not they're going to approve the medication. Big difference between Blue Cross and Blue Shield, where you plunk your card down and you get what your doctor wants, versus workers' comp. Every single prescription request that I put into a carrier has to be separately approved. So this infinitum issue of things going on forever, or somebody, recommending cannabis for an appetite disorder somehow being related to a workers' compensation injury, will be tested in 3 ways. Number 1 is I got to get a doctor to say it. Number 2, the insurance company has their doctor look at it and oftentimes will say no. And then we go to a commission hearing, and the commissioner decides whether to believe their doctor's opinion or my doctor's opinion, and the claimant testifies as well. So, and reasonable and necessary is not just based on a commissioner making his or her own independent assessment independently of the evidence. They are informed by the insurance company doctors about reasons that they believe it's not reasonable, it's not necessary, or it's not causally related, and it happens every single day. In terms of some suggestion that somehow this bill is helping trial lawyers get rich, when I go to a hearing on a medical only issue, we are not allowed to collect a fee from the claimant, and we are not allowed to collect a fee from the carrier. We have to do that work for free and get paid perhaps later on if we get indemnity benefits for the claimant. So there is no endless, blank check for prescription medicine, because what happens is the carrier routinely monitors the claimant's level of consumption, and at some point files issues for what's called weaning, where they bring my client in and they say, we don't think you need the opiates anymore, or we think they're no longer productive for you, and we're going to get you into a program to get you off of them. So there is no blank check that goes on forever. In terms of allowing employees whose doctors recommend cannabis as opposed to other drugs, that the judgment call as to whether marijuana is an appropriate medical response has already been made. The General Assembly's already decided that cannabis is an appropriate drug for Maryland patients, assuming the treating doctor believes it's reasonably necessary. So why not workers' compensation claimants whose treating doctor believes it's reasonably necessary and causally related? and approved by the insurance company representing the employer, or after a hearing where everybody's had a chance to put all the facts on the table, expert and lay opinions. And also in terms of somehow you're licensing people using drugs on the job. Using drugs on the job is always wrong. And by allowing somebody to take a type of medication because their doctor believes it's appropriate, doesn't license that person to then go fly an airplane after he smoked marijuana or has taken opiates. Employers will still be allowed to control the safe operation of their equipment by people by making sure that they are not intoxicated or inebriated on the job. The injured workers are entitled to the same right to health care that other Marylanders are. If your treating doctor believes that medical cannabis is appropriate for you and you want to use it, you should have that right. And therefore, we urge favorable report. Thank you.
Jim, let me ask you something. Just based upon your last couple of lines, something just sort of clicked for me. You said that I guess the employer would still be able, to control, I guess, using drugs on the job and things of that nature. But it got me to thinking, if as an employer, that your employee is taking medical marijuana, that they're using cannabis, I mean, this, and that it can have a high effect that could lead to whatever. Would that be a negligent hire at that point if they were to cause an accident or an accident involving this person? It turns out that they had cannabis in their system, and we know that cannabis, among all the good things it can do, it can also have that high effect. Did that employer just open themselves up for a negligent hire charge?
Well, negligent hiring means that the employee was impaired or under the influence of the drug at the time. Merely having it in the system is not the basis for a lawsuit for negligent hiring. So I suggest to you, Mr. Chairman, that's currently the law with regard to the opiates that are being prescribed for these people by other doctors. So if your employee gets injured on the job and your employee is taking prescription medicine, we don't care what kind of prescription medicine is, that impairs that employee's ability to drive a tractor trailer or equipment or a car, we would hope that the employer exercises reasonable care to make sure that the employee is not under the influence of that drug while driving. So I don't think it changes the law. It merely says that the employer is as responsible as they were under the current system. Does that answer your question?
Yes, it does. Yes, it does. I was thinking a previous issue we had talked about, and I was wondering if in this scenario, could that lead to outcomes we discussed previously? That's what I was wondering.
And the answer is, I don't think so, because merely testing for it isn't enough. You'd have to show the employer knew or should have known the person was under the influence of it. And marijuana, by the way, you can test positive 30 days after smoking it. And unless you have the lowest tolerance in the world, nobody is still under the influence or impaired that far out. So actually, I think it would be tougher as a plaintiff's lawyer. If I'm suing an employer and you just show a test positive for marijuana, but no supporting facts, showing loss of coordination, I think it would be tougher to sue than if you tested positive for opiates.
Fair enough. Did I miss anybody? If not, thank you.
Mr. Chairman, can I add one thing?
Sure.
The reason we proposed the amendment, which allows reimbursement, comes out of one of the earlier witnesses mentioned this case in New Jersey. Some of the insurance companies, when we had a legislative oversight committee years ago, said they were apprehensive about being ordered by the commission to pay for a medication that, though legal under Maryland law, is illegal under federal law. And to resolve that, what some states, New Jersey included, have said is you reimburse the claimant for the claimant's out-of-pocket expense. It doesn't change the balance sheet entry, but that's the reason for the amendment. I just want to make that clear.
Got it. Christy Megna, Maryland Medical Cannabis Commission.
Chair Davis, honorable committee members, thank you for this opportunity to be heard. My name's Christy Magna. I'm a senior regulatory analyst with the Maryland Medical Cannabis Commission. I'm representing the commission in support of Delegate Valderrama's bill. This is significant legislation. What it will do is, by legislating in this area, you will clarify the law, alleviate confusion, help to alleviate undue litigation expenses, and be able to give peace of mind to the workers so that they know exactly what to expect in this realm. As the sponsor indicated, 5 states already officially require medical cannabis reimbursement under workers' compensation claims. And as the previous speaker also noted, there was a Carroll County Circuit Court appeal case that the outcome was reimbursement for medical cannabis was ordered. So medical cannabis is medicine. What this bill in part does is it acknowledges and clarifies that medicine, including medical cannabis, obtained in accordance with written certification under the medical cannabis program. So the Circuit Court case in Maryland, it gave affirmation to the fact that medical cannabis is medicine. If you look up just the plain meaning of the word medicine, it's a drug or compound or preparation used to treat or prevent a disease or condition. In addition, the acknowledgement of the reimbursement for the medical cannabis, it comports with an already existing Maryland statute that says a Maryland medical cannabis patient may not be subject to prosecution or arrest or receive a civil or administrative penalty and may not be denied any right or privilege for the use of medical cannabis. So House Bill 683, it represents an important advance in creating equity under the law for medical cannabis patients. Parity in workers' compensation cases for medical cannabis patients as already exists under the coverage for those who are receiving prescribed pharmaceuticals is an acknowledgement of the reality of the value and the use of medical cannabis to treat various medical conditions. This is consistent with a number of other areas across the code. There's already parity between prescription pharmaceuticals and medical cannabis in that they're both exempt from the state sales tax. Both may be administered to students who are medical cannabis patients in schools, and they both have certain advertising restrictions. Workers' compensation coverage was created for humanitarian purposes. In this spirit, medical cannabis can be an effective and humane treatment for chronic and severe pain. Medical cannabis can also serve, as previous speakers noted, as a less addictive alternative to opioids with fewer side effects and no risk of overdose death. In the past, other jurisdictions have raised issues about reimbursement for medical cannabis due to the fact that it's illegal at the federal level under the Controlled Substances Act and concerns about potential federal entanglements. It's important to note that there have not been any federal prosecutions under the CSA against employers or insurance companies who reimburse for medical cannabis. Further, the workers' compensation coverage for medical cannabis is not in direct conflict with the Controlled Substance Act because it doesn't involve possession, manufacture, or distribution of the cannabis. It's just responding to an order to reimburse the medical cannabis. Lastly, at the federal level, the federal government has typically afforded great latitude to states with respect to the practice of medicine, which the Controlled Substances Act was never intended to regulate. If the bill is enacted, the Workers' Compensation Commission would set the applicable rate of reimbursement for the cannabis by their regulations and their fee schedule. Because other states already have this, we could use that as an example for how to adequately reimburse for the cannabis, which typically in Maryland averages $300 per month, which is lower than the national average. Thank you for your consideration of this bill, and we appreciate sponsor Valderrama's leadership in this area.
Delegate Demay.
Thank you, Mr. Chair. I served a long time on the House Judiciary Committee, and we were the committee, sometimes jointly with the Health and Government Operations Committee, that heard the testimony regarding medical marijuana or cannabis, which is the more correct term. But then once we passed it, we were also involved in sort of working through setting up the commission and the standards or whatever. And I wonder if you could give the committee, there's been a lot of questions today sort of about what does medical cannabis do? But there hasn't really been an answer to the regulations. For instance, is there a regulation regarding how much, and I always get the initials mixed up, THC can be in a certain amount of marijuana? Isn't it correct that in fact your commission regulates what is sold and in what amount it can be sold?
That's correct. It's set in regulation, the amount of THC, the capacity that it could go up to. And I also wanted to mention that because we're talking about the workplace and because medical cannabis is prohibited from use in a public place, like you would not be able to be smoking in your place of employment. So typically the worker would be using what we call a cannabis infused product, which comes in many forms. It could be a dermal patch or a salve or a wax or a suppository. And those forms, they're longer acting and they are used like in micro dosing. So you wouldn't see the kind of highs that you could obtain necessarily from using combustible cannabis.
And isn't it also correct that the medical marijuana or medical cannabis shops are also very highly regulated as far as, who can enter the shop, who can, and in fact, you have to show your identification before you're allowed to go back into where there is sales. The number of people that can be in the shop at any given time are also regulated. And that the licensing process is rather stiff. Is that all correct?
That's correct. It's very highly regulated, very prescribed by our regulations. And also, as a previous speaker mentioned, the dispensaries now require that each dispensary has a clinical director who would either have the same qualifications to be eligible to be a certifying medical cannabis provider, a licensed pharmacist, or else someone that the commission approves because they have adequate training and experience, who are advising people who are coming in and purchasing the cannabis, and who also work with the certifying providers to help educate them about the appropriate strains and types of cannabis for the particular malady that a person is trying to treat.
Thank you.
Delegate Howard.
Thank you, Mr. Chair. Christy, isn't it true that that court case that you referenced in Carroll County is on appeal?
So it was on appeal, and then before the case was heard, it settled. And the underlying decision by the commission was,
reimbursement for medical cannabis, and then it was appealed. The settlement included affirmation that yes, there would be reimbursement for the medical cannabis.
And isn't it true that that judge awarded those direct compensations based on a direct adverse reaction to narcotics by the patient?
I'm not exactly sure of all
I'm looking
the
at the case.
underlying.
I'm looking at the case now, and it is. And one of the arguments that I'm concerned about is, and I think it's a valid point, is that the insurance companies are concerned, and again, I rightfully so, that because they do business over state lines and they would have to pay medical marijuana cost in Maryland, they're concerned essentially that it would put them up against some type of federal laws, practices, licensing, and regulations. Isn't that also true? That's one of the arguments that they made in court when the ruling was appealed.
So in other jurisdictions, in other states that officially require reimbursement for medical cannabis, many of those appellate cases argued what you're talking about and refuted it and held that that was not, they did not side with those arguments in the appellate decisions in other states.
At the state level appellate courts? Of those other five states?
Right. So Maryland, how we have the Court of Special Appeals,
right,
and then the Court of Appeals in our appellate structure, whatever courts are called in their appellate structure, where they decided the case.
Right, but has any of the, because we are talking about insurance companies and they do business over state lines, have any of the federal courts weighed in on this? Because those, those insurance companies, like I said, they do business over state lines. The federal jurisdiction is in play. Has there been any federal language, any federal ruling, anything from the past administration, the current administration, on how they would handle any of this? And how long has those other 5 states that has passed this legislation, how long has that legislation been in effect? I mean, did the legislation pass in like 2017, or seems like it's all fairly new?
So it's fairly new. I think New Mexico was the first, and that it went back maybe 5 years, but they've all been very, very recent. And I also clarify that the official requirement in these other states, like they decided these appellate court cases, stare decisis, it's controlling for the state. These requirements were decided at the appellate court level. Now, there are right now a handful of states that do have pending legislation to codify those types of decisions, just as the sponsor's bill does here. It would be a codification of this coverage.
Because I remember before Trump, during the Obama administration, one of the things that they were talking about was legalization of marijuana, and Johns Hopkins didn't even touch it because it was still, even though it was okay on a state level, it was still not okay on a federal level. But I'll do some more research. I appreciate it. Thank you.
So I do believe with Hopkins, they were concerned about loss of federal funding. And that was part of the discussion there. But if you look at the guidance coming from the US Justice Department, beginning with the Obama administration and to the current, the guidance is that when it comes to lawful medical cannabis and well-regulated as ours is, medical cannabis programs, it's being left to the the state attorney general to do the enforcement, just make sure everything is running properly. Medical cannabis programs, it is not part of the listing of federal priorities for doing federal enforcement on cannabis. When they listed out what their priorities were, it was like hands-off approach with respect to medical cannabis at the federal level. And then they listed their priority areas, which focused on adult use cannabis and drug cartels and violence and gangs and drug trafficking and so forth.
But it's from an insurance company perspective. Right now, we don't have any indication from this administration, previous administrations, or otherwise in what direction the federal government could go. Is that correct? And I think that's one of the insurance companies' big concerns.
Well, I mean, people make different blanket statements, and there are fears that things need to be examined. But if you look at the evidence, there's no past history or threat to this type of thing. And in fact, there's increasing evidence of more acceptance and support for medical cannabis. And I think part of it has to do with education and awareness, and part has to do with the legitimacy and the realness of this type of medication for patients. I mean, there are medical cannabis patients who have tried pharmaceuticals and they're managing their conditions better with medical cannabis, and they're even patients with serious conditions who have less hospitalizations. I mean, some of the patients' stories of what they've been living with and how cannabis has helped them manage their condition and elevate the quality of their lives is pretty inspiring.
I agree, but those stories have been around for years, and no administration prior, or even this administration, the current administration, is really taking and sort of leading the bull by the horns as far as the federal level is concerned. So I get what you're saying. I've got some concerns about federal statute and our insurance companies based here in Maryland and doing business across state lines. So thank you very much.
Thank you.
Watson.
Thank you, Mr. Chair. I think following up with Delegate Howard's concern, it would be good to know, and I guess this is directed at the sponsor, but there could be someone else in the room that knows the answer. It would be good to know what's happened to the other 5 states. For example, have any of the workers' compensation carriers pulled out of the state or declined to write workers' comp insurance in the state? One thing Maryland has is a very healthy and robust and competitive workers' comp market. And I wouldn't want to see that change if we had fewer carriers that were willing to write. So it may not have an impact on that at all, but it would be good to find that out. Thank you, Mr. Chair.
Thank you. Any additional questions? If not, thank you very much. Joe Xavier.
Thank you.
Great. Thank you, Chair Davis, and all the members of the committee. I'm Joe Xavier, and I'm here on behalf of Associated Builders and Contractors. I'm the CEO and Senior Consultant for Summit Sustainability Solutions. I'm a safety consulting company based here in Maryland. And our response to this bill is a little complex, as the bill itself is complex given how short it is. But the Associated Builders and Contractors supports HB 683 with significant amendments. The part that we're favorable on is Labor Employment Article 9-506 B2, Roman numeral 2. We do believe and concur with that portion of the bill. Our amendment speaks to the fact that the construction industry and the construction sites are constantly changing, and we need a workforce that is fully alert and free of influence from any substance. To Mr. Shepard's testimony, the construction sites are very dangerous. They're very dangerous even when someone is fully alert, even when someone is not impaired, even when someone can make good judgment, even when someone has full control of their motor skills and coordination. So it's a very dangerous place. Additionally, any modified duty activities would be difficult to accommodate if a person is still using cannabis and has that within their system. So because of those factors, ABC is asking for an amendment that essentially excludes medical cannabis from the Workers' Compensation Commission entirely. If that is not, if that cannot be adopted in the alternative, we'd like to give special recognition and have that afforded to the construction industry itself. And if we could add into 9-660 paragraph A3 to add paragraph I, that medical cannabis is prohibited from the construction industry, meaning all business with a NACE code beginning with 2-3. So I agree that we have learned a very hard and difficult lesson from opioids, and we don't want to repeat the same type of lesson with medical cannabis. Thank you.
Any questions?
Mr. Chairman.
Delegate Valderrama.
Thank you, Chairman Davis. Mr. Xavier, just so I'm clear, you favor the bill with an amendment, which would be to strike the bill in its entirety because the whole premise is to add medicinal cannabis to the list of medications. Is that correct?
So the first part of the bill, I think it does recognize that cannabis is a drug, and it does have certain provisions there. So we agree with that. The second part of the bill, specifically that third paragraph, we would like to see it excluded instead of included. And that's our amendment. In the alternative, if it is to be included, we're asking that we at least separate the construction industry from that requirement.
Right. So to exclude it is the gist of the bill, is what I'm trying to clarify and confirm. Because all we're doing, and I don't mean to make it less than, but we are simply trying to just add medicinal marijuana to the list of meds that are an option. So if that doesn't happen, which I'm right now at this current moment is unlikely, you're saying if that doesn't come out, just exclude the entire construction industry.
That's correct. So we do agree with the first half of the bill, and we would have amendment to the second half of the bill.
Okay. And when you say the entire construction industry, because I'm not a construction worker, but I know there's a lot of, heads and tails about it. Like, there's not just one definition, but in its entirety is what you're saying, just so I'm clear.
Right. So the NACE codes are how businesses, identify unemployment, and then we're
what was that
talking
code
about all
again,
the
sir? Can you give me that code
NACE,
again?
the NAICS codes.
Okay.
It's a six-digit code.
Okay. Thank you very much. Thank you, Mr. Chairman.
Delegate Johnson.
Thank you, Mr. Chairman. Mr. Xavier, do you have any stats for us on how many accidents last year in the construction industry were due to painkillers or pain medications?
I do not have anything specific to Maryland, but if you look at the Associated Builders and Contractors 2020 Safety Performance Report, there is a statement that states that 1/3 of all workplace injuries in the construction industry are somehow related to either drugs or alcohol.
Okay, thank you.
Thank you very much. Last witness, Robert Denton. Robert Denton. If you're with us, you're muted. All right, that concludes our hearing on House Bill 683. Delegate Valderrama, we can now go to House Bill 684.
Okay. Oh, am I on? Okay. Thank you, Mr. Chairman. Again, for the record, Delegate Valderrama here to present House Bill 684 entitled Professional Land Surveyors Surveying Practice Definition and Licensing Exception. It is the premise of this bill that this bill would basically modernize our current statute. House Bill 684 is the result of a collaboration between the Board of Professional Land Surveyors and the Maryland Society of Surveyors in an effort to modernize the definition of land surveying. Advancements in technology in the field of land surveying are changing faster than any time in recent history. Surveyors now use drones, 3D scanners, robotic total stations, global navigation satellite systems to perform data acquisition. Therefore, the definition of land surveying needed to be modernized to account for these changes in the rapidly changing technology. The primary revision in House Bill 684 relates to specific quote unquote instruments of measure, such as aerial photogrammetry, global positioning systems, and geographic information systems that will be eliminated from the regulation because of advancements in technology. And in addition, the proliferation of topographic data, capturing devices like aerial drones, has made this type of data collection more readily available. So that topographic data collected by an entity with certifications that are deemed acceptable by the licensing board will not need to be performed by a licensed professional land surveyor. Apologize. The revisions to the Land Surveyors Practice Act does not reduce the current scope of the practice of land surveying and does not limit the scope of other design professionals, for example, professional engineers and landscape architects. The bill simply eliminates references to antiquated methods of data collection and positions the definition of land surveying for future technological advancements. And with that, there is an expert panel that will further explain the bill because I by no means claim to be a professional land surveyor, nor architect, nor engineer. But to me, the bill seems pretty straightforward and just clarifying and making our current statute more modern, as I mentioned earlier. And with that, I would like to urge a favorable report on this bill. Thank you, Mr. Chairman. And if I can I ask who the lead witness would be? Is that appropriate?
There's only three: William Kress, William Bauer, John Meddy.
I'd like Mr. Bowers to go first, if that's possible.
Sure.
Thank you, Mr. Chairman.
William Bauer.
Thank you, Mr. Chairman. Thank you, Delegate Valderrama. That was an excellent synopsis of the proposed legislation. I'm with the Maryland Society of Surveyors. We propose to modernize the Land Surveyors Practice Act by simply removing references to specific methods of data acquisition and to allow the licensing board greater latitude when reviewing cases against entities providing topographic data acquisition services. We feel that these changes will position the surveying profession to assimilate future technological advances while continuing to protect the safety and welfare of the general public. Thank you.
Any questions? Seeing none. John Matee.
Sorry, Mr. Chairman, it took me a while to get the unmute button working properly. But my name is John Matee III. I am a licensed surveyor. I am also a chairman of the licensing board, and I'm not speaking here on behalf of the licensing board. I understand a letter was sent from the board on behalf of favoring this legislation, but I'm here to speak on behalf of this legislation as a surveyor. And my career has spanned over 37 years already. I've been a professional since 1987. And I've seen the technology change over the course of my lifetime. When I first entered into surveying, I entered in using an engineer's transit and a tape, which was very similar to that of our ancestors in the way they surveyed. I tell a lot of individuals that I'm very fortunate to have been born in the time frame that I have because I've seen the explosion of technology. The way we survey today is a lot different than the way it's done in ancient times and in years gone by, using the computers, technologies, calculators. It's just unreal how much work that can be accomplished using technology. So I'm here as a surveyor in support of this legislation, of this change. I believe the surveyors commonly refer to this as the Practice Act. And it hasn't been changed in over 20 years. And it is time for the language to, in fact, be updated. And part of the provision in this language makes a provision for those that acquire this data that are certified by other entities that are not land surveyors. We feel that where technology has gone, the use of the technology is being used, and these other entities that are certifying these individuals, that certainly this is one aspect of the land surveying that can be accomplished by these certified certified individuals that are not professionals. So again, I thank you for this time, and I would recommend a favorable report.
Any questions? Seeing none, thank you very much. Bill Kress.
Thank you, Mr. Chairman, members of the committee. Bill Kress here today on behalf of the Maryland Society of Surveyors. I'll be very brief. Just want to let the committee know there is no opposition to this bill. The licensing board and the society have worked on this issue for well over a year. They also had held meetings with different chapters of the surveyors to get their feedback, and this is a collaborative effort, as the witnesses have said, which will update the act, and we would urge a favorable report. Thank you.
Any questions? Seeing none, thank you very much. That concludes the hearing on House Bill 684. I'd now like to go to the final bill of the day, House Bill 685, Delegate Valderrama.
Thank you, Mr. Chairman. Looks like it's Valderrama Day today, and there won't be many more of these. You can rest assured, except for next Monday or Tuesday. I think that's the 23rd. But having said that, appreciate your patience, colleagues. Here to present the last bill for today, House Bill 685, not a new bill to this committee, the Maryland Secure Wage Act. Just a friendly reminder, this bill was prior Delegate Branch's, prior to that Chairman Davis's, if that's any helpful information for this current bill that I'm about to present. In all seriousness, it's an important bill, though I will preface by saying there were many amendments made to this bill. And again, I just checked the floor system. They are not listed. So before there's 20 million questions surrounding the current language in this bill, just reminding you that there are many amendments to include. We've taken out restaurant association workers, we've taken out rental car workers, we've taken out, I don't have the list in front of me, unfortunately, but there is quite a few. So just please, colleagues, keep that in mind. With that said, what this legislation, this measure seeks to do is to improve wages and health benefits, which will help attract and retain experienced and better trained workers at BWI, Marshall Airport, Penn Station in Baltimore, and the Port of Baltimore, sites that are all critical to keeping our crippled economy running. What this bill also seeks to do is to ensure that employees at these key transportation facilities will be paid no less than the Combined Service Contract Act, the SCA, wage and benefit rates for Guard 1 in the applicable county, which is currently $14.32 per hour plus a $4.54 per hour supplement for benefits. A higher wage is appropriate for the essential workers at heightened security locations because of their importance in supporting and securing our crucial infrastructure at these locations. So workers who need security clearances and specialized training also deserve a pay differential, particularly when these same workers have worked throughout the pandemic that we are still in and at greater risk to their health. The other two airports in our area, Reagan National and Dulles International, both pay workers in security areas more money than other employees outside security locations. This is so not just as a matter of fairness, but for the practical reason that low wages are a key factor in one, rapid turnover and poor performance among employees. Two things that do not complement security in a heightened security area. So for this reason, a similar wage structure to the one I am proposing is already in place at Newark, Liberty, JFK and LaGuardia on the East Coast, LAX, Oakland Airport, and the Port of Oakland on the West Coast. So while reports document that the Port of Baltimore and freight services at BWI is undergoing a strong rebound from earlier losses, it is indisputable that COVID has had a devastating impact on passenger air service at BWI Marshall and on the retail, restaurants, and rental car companies that do business there. So it's for that reason, you will find an amendment to this legislation, as I mentioned earlier, that excludes all restaurants, retail, on and off-site rental companies, and construction at these 3 locations. It is our hope, or what we seek, that by excluding these businesses, it's our hope that opposition to this legislation will disappear, but we all know that never happens in any legislation process, and that we will all attest that all these hardworking employees will earn the pay increase, the health benefit that they need to support themselves and their families in these unprecedented times. And so, colleagues, with that, I would just ask a favorable report and urge a favorable report on House Bill 685.
Thank you very much. Jaime Contreras.
Good afternoon, Committee Chair Davis, Vice Chair Dumais, and committee members. Thank you also to Delegate Valderrama for such an eloquent introduction of the bill, and also for expressions of support of the airport workers, Delegate Branch, Rogers, and others who also expressed support for our members. Again, my name is Jaime Contreras. I'm a Vice President for SCAU 32BJ. Thank you again on behalf of our 20,000 members in Maryland, in the DC area, for testifying here today. As you've heard before, I'll try to summarize as much as I can from this bill, because we heard this at the last hearing last year. But yes, this bill will basically help make the state safer by ensuring that experienced workers stick around in these jobs. These are heightened security locations, and this bill will also ensure that you're making a transformational difference in the lives of these hardworking men and women. At the same time, the bill will protect the traveling public and essential workers by providing enough money for healthcare benefits for essential frontline workers, which all these workers are. The majority of the service workers at these facilities are Black and brown and are the most at risk for contracting COVID or dying from COVID. They also often don't have access to healthcare or affordable healthcare. Given that the Port of Baltimore is a major shipping terminal, workers are always the eyes and ears against the constant threat of illegal activity at this facility. And as you already know, research has shown that higher wages and benefits and good treatment of workers really does correlate to reduced employee turnover. And in security and safety roles, this has shown to have measurable impact on security outcomes. And you've heard that you're not alone in doing this. LAX, Oakland Airport, the Port of Oakland, New York airports, Dallas and DCA and other airports have already done something similar. So it's time to do it at BWI and this other heightened security in Maryland. So setting a minimum wage and benefit rates for based on the prevailing area standards for security guards doesn't really mean luxury for these workers. These rates are by definition the industry standard, but they also mean access to meaningful health care outside of public programs, which these workers right now have to rely on. Setting a wage standard also eliminates the race to the bottom that we often see happen to employees of service contractors engaged in competitive bidding. That's just the nature of the beast. But contracting work isn't the problem. It is really only a concern when it comes without any safeguard for the workers. So enacting wage requirement at these transportation facilities will really mean that contractors would compete on the basis of their ability to manage the work and their expertise in the industry, and not who can cut the wages the most or benefits, or who can cut the benefit the most. And finally, restoring public confidence, I think we can all agree, is crucial to getting these very important transportation hubs back and running. These are key economic drivers in our area. and easing access to healthcare, health insurance will go a long way in meeting that goal. So I appreciate the time, and I urge you to support this bill and make this a reality once and for all for these workers, help make Maryland safer while improving the lives of thousands of hardworking men and women. Thank you very much again.
Rudaini Jabai.
Yes, sir. Hi, everybody. My name is Rudaina Jabai. I work as a wheelchair attendant for a subcontractor that services Southwest Airlines at BWI. We are paid below the minimum wage because we might get tips from passengers. However, the majority of the time, we don't get any tips. I can't afford to buy the company health insurance, so I have to rely on Medicare. Access to affordable health insurance is important to me because I am diabetic and have high cholesterol. I am an essential worker on the front lines risking my health. We are in a high-risk area to contract the virus since we work in the airport. On the top of that, our job requires us to be closer than 6 feet to our passengers. We try our best to take safety precautions, but it is still very dangerous. I am taking care of my elderly mother, so I am terrified of bringing home the virus and getting her sick. I don't want to quit my job, so I'm working less hours now just to be sure I don't spend too much time in a high-risk place like the airport. But this has brought down my income a lot, and I have to ask for help from my family just to pay my bills. Please, pass this Maryland Secure Wage Act. We can't go on living this way. Thank you.
Thank you. Akalu Turfy.
Good afternoon. My name is Akalu Turfe. I work as a passenger service agent for a contractor, Prospect Airport Services at BWI Airport. I help people with disabilities to get to their flights in time and help them with their luggage. I walk up to 12 miles a day, sometimes even running when a passenger is late for his flight. My job is so physically exhausting that it's impossible for me to take on another extra, at least a part-time job. This means my income always falls short. In addition, I'm left with physical problems like back pain. I'm also at high risk of developing severe illness from COVID-19 because of my age, my high blood pressure, and diabetes. The health insurance that my employer has is so expensive that I can't afford it and must rely on Medicaid instead. I'm also struggling to pay my rent and provide for my family. I live paycheck to paycheck. The Maryland Secure Wage Act is the only remedy that would help me, my coworkers, and our families. Thank you.
Thank you. Reverend Kobe Little.
Good afternoon, Mr. Chairman, Madam Vice Chair, members of the committee. It's always good to see you. Thank you for your work in this very difficult time. A special thanks to Delegate Valderrama for continuing to sponsor this important legislation, House Bill 685, the Secure Maryland Wage Act. I'm Reverend Kobe Little. I represent the Maryland State Conference of the NAACP. I serve as Vice President and Political Action Chair. We stand in support of the essential workers that you've heard from already today, and stand in solidarity with SEIU 32BJ, and asking this committee to find favorably on House Bill 685. 4 quick points I'd like to make. Our transportation hubs are economic engines. As these economic engines create economic opportunity and facilitate business, the people who make these economic engines go must not be left behind. House Bill 685 will ensure that they're able to move forward with economic opportunity that's created by the institutions they work for. The second point is that every person who works at a Maryland transportation hub should never have to worry about paying their bills. Every person who works at a Maryland transportation hub should be confident that their health care is covered, and this legislation will meet those needs. Finally, the third point I'd like to make is just to bring us briefly back to the events of January 6th. We know how important security is and how fragile security is. That's why it's important to make sure that in our airports and train stations, essential workers, whether they are security guards or they are passenger servants, agents, or they work in baggage claim or in other areas of the airport, it's important that they have the support that they need so they can show up as part of the critical infrastructure to keep our transportation hubs safe. And finally, this bill was before you last year, but it's back again this year. And in the face of the pandemic, I appeal to each of you to support this legislation and to pass this legislation out of committee favorably so that there's no worker at a Maryland transit hub who is without the health care that they need, without the resources that they need to take care of their families. Thank you.
Thank you. Peter Adagaki.
Good afternoon.
Good afternoon.
Yes, sir.
It's your turn.
Thank you, sir. Hello, sir. My name is Peter Adegoke. I work at BWI Thurgood Marshall as a passenger service wheelchair attendant. I'm a tip worker, which means I'm paid below minimum wage. I have to rely on tips from passengers. Unfortunately, a lot of time I don't even make any money in a day, especially that there are less passengers. I'm the front runner every day dealing with passengers, and the airport a public place, which is very risky, filled with people. You can imagine how cautious I have to be about the COVID-19 all the time. It's a very big risk, but I must work compulsory. The work is very hard at bodies, but there's nothing I can do. I have to work one more time. I have recently to stop working 2 months ago because I injured my back while pushing a passenger. Nobody cared. I feel the pain, but nobody cares. I have to go home and take care of myself. I have no income for these 2 months, and it was really hard for me. It was a terrible situation. Moreover, my medical bill were not fully covered by my employer, the one they gave me. Now I don't have insurance at all because it's very expensive. I'm scared what will happen to me if I injure my back again. I have no coverage. I have to support my mom back at home because she was paralyzed. My income cannot, I just have to help her because it's my mom. Passing the Secure Maryland Living Act, I will give me my co-worker a raise that we deserve and money towards healthcare costs, so I could actually afford to take care of myself because the situation was terrible. That is my contribution, sir.
Thank you very much.
You're welcome, sir.
Rabbi Alana Suskin.
Sir?
You're up.
Say again, sir. Say it over again. Let me hear you.
I'm calling on Rabbi Alana Suskin now.
Okay, I got you. Thank you very much.
Okay, I will assume Rabbi Suskin is not with us.
She might be in the waiting room. And I'm gonna, because there's something that says that a Jewish host is there. So I'm gonna admit that person. I think that's who it is.
Do we have Rabbi Alana Suskin with us?
Still joining.
Then let me come back. I'll call her again. Let me go to Arnita Washington. Is Arnita Washington with us? Is Lydell Hills with us?
Yes, yeah.
Welcome.
Yes, all right. Hello, sir. So, thank you, Chairman, for the opportunity to speak today. My name is Lydell Hills. I'm here on behalf of Organizing Black. And we're here in solidarity with the airport workers as well as the union at CIU, 32BJ. And so here today, I just wanted to uplift a few different points in the stories that we heard from some of the airport workers as they were trying to highlight some of the issues as to why like this bill needs to get passed. So first, and just how like they described and educated us in understanding the role and position and the necessity of retaining the workers and retaining experienced workers at the airport, as is like a high national security position. A lot of the workers have discussed the importance of being able to like for the experienced workers to be compensated appropriately and to be able to have basically benefits to this job that continue to incentivize workers to stay on, continue to gain experience, and to stay involved in this workforce. A lot of the workers have also felt silenced and feared being able to come up, bring these issues to light themselves as they've had to unionize, and any workers that have unionized, or there have been stories of certain workers who have been fired and or did not have access to higher benefits and better wages. And so essentially it's the importance of bringing this issue up today is that there's a lot of workers who also can't even Hello, can you still hear me?
We can't now.
For a second.
You froze for a bit.
Okay, well, so basically on the last part, I was just emphasizing that there's a lot of workers who can't be on the calls today to represent themselves, and they can't represent themselves in their workplace because essentially their managers have threatened and already taken action to prevent them to be able to stay employed at those at the various locations they mentioned. And just the last thing I want to bring up is that for these workers, it's majority of Black and brown workers who coming from more impoverished backgrounds, who are a lot more vulnerable to threats that we're talking about with risk of employment and being fired, and need more support in terms of like transportation and healthcare to be able to show up at work and to support the families that they have, especially the experienced workers. We're talking about folks who have families and have been committed to their jobs for a long time. And so this is also where their experience lies. And so we ask that you push this bill forward, representing the airport workers and advocating for better wages and healthcare. Thank you.
Rabbi Alana Suskin.
Hello. Thank you, Chair. Thank you, delegates who are here today. I want to offer honor and respect to those workers who were speaking earlier. As a rabbi and as co-chair of the Maryland Poor People's Campaign, I'm here to speak in favor of the Secure Maryland Wage Act. These workers are on the front lines of providing safe transportation across Maryland. While it's a moral and biblical imperative to provide safe working conditions and appropriate remuneration, especially at this time, we need to make sure that these essential workers, crucial to the functioning of our infrastructure and thus to many other essential workers as well, are provided with a living wage and health insurance. Scripture emphasizes in several places the obligations that we have towards workers at all normal times. We're always obligated to minimize risks to them, to pay them adequately and on time. But in a time of pandemic, we have a special obligation to make sure that their safety is secure and that they themselves are able to access healthcare. In addition, Scripture also tells us that all of humanity has one ancestor and that we are all made B'Tselem Elohim, in God's image. And so we're obligated to fight racism and unequal treatment. We also know that the majority of low-wage workers at BWI are people of color. By raising wages and giving access to quality healthcare, we begin to address this inequality and uplift not only these individuals, but their communities. This is especially important now, since it is also people of color who have been most affected by the pandemic, more likely to lose jobs, to face foreclosure, and to become ill and to die of this disease. This is morally wrong as well as bad for our state. No truly religious person offers mere thoughts and prayers. God demands action and change. As a representative for the Maryland Poor People's Campaign, as well as a woman of faith, I call on the state to pass the Secure Maryland Wage Act. Thank you.
Thank you very much. Daniel Butler. Daniel Butler with us. If not, Sean Malone.
Thank you, Mr. Chair. On behalf of Southwest Airlines, my name is Sean Malone of Harris, Jones & Malone, testifying in opposition to House Bill 685. Southwest Airlines accounts for 66% of all flights at BWI. We employ 4,900 employees, and those 4,900 employees are under a union contract, not represented by SEIU. The majority are represented by the Teamsters. We have in place fair wage scales negotiated with the Teamsters. We have in place healthcare benefits. At this time in Southwest history, we lost $3.1 billion last year. We were going on pace to lose another billion this year, but we honored every clause of each contract we had with our workers. We had no layoffs. We had no pay cuts. We did not reduce hours. We did not negotiate a reduction in retirement or healthcare benefits. We honored those benefits. We do not believe that we should be included in this act. And in fact, with regard to the testimony, the airport workers' wage policy at Reagan and Dulles does not cover the airlines. The policy there does not include healthcare in the wage. And in fact, it is a phase-in that started at $11.55, and by January of 2023, we'll get to $15 an hour. This is a full $4 an hour sooner, higher, about 2 to 3 years quicker. The wages at the airport generally are above the surrounding prevailing wage. However, with regard to the airlines and the employees we represent, I would urge this committee to do as it did when we looked at the Maryland Healthy Working Family Act and respect the negotiations that go on between the company and the union that represents our employees. As you guys know, many things are given up on both sides in the negotiation to reach a contract. To intervene in this contract, and in essence, I think on page 6, line 17, negate the wage provisions of the contract should they fall below an $18.90 an hour wage, is interference that I don't think that this bill is intended to do. So we would urge that we would urge an unfavorable report, but if we were to send this out, we would ask that this not apply to airlines or businesses who have engaged in collective bargaining with their employees and reached an agreement. With that, I submit. Thank you.
Melvin Thompson.
Thank you, Mr. Chairman. I'm Melvin Thompson. I represent the Restaurant Association of Maryland, and we oppose House Bill 685 as it is currently drafted. However, we have requested an amendment through the bill sponsor to address our concerns, and we would withdraw our opposition to this bill upon the committee's adoption of amendments to exclude food and retail vendor employees from the definition of covered employee. And we have seen the draft amendments, and we sincerely appreciate the language in the proposed amendment that excludes food service and retail workers. However, that does not mean that we support other language that was added to the amendment regarding tip credit for wheelchair attendants and other passenger service employees. We have no position on that language, and we think it's necessary for us to make that important clarification now that the amendment language has been expanded. Thank you very much, Mr. Chairman.
Thank you. Are there any questions? Seeing none, that concludes our bill hearing for House Bill 685. And that concludes the bill hearings for today, Tuesday, February 9th, 2021. Thank you all. Thank you to all of our witnesses who testified. We appreciate you, and everyone have a good day.